The First Amendment is first for a reason. The Second Amendment is just in case the first one doesn't work out.
U.S. Appeals Court has overturned Maryland's licensing requirements in order to buy a firearm. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for entering certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. Public service announcement. Like I told you, I'm going to keep saying it. Those of you in Connecticut who want to get your Connecticut pistol permit, please do it before July 2024. The state has changed their training requirements, making it more expensive, harder, and more onerous to do so. And obviously, this has nothing to do with safety. It's truly just about making it harder for the average person to get licensed to then go buy a firearm. And that's our ultimate goal. So please get it done. July 2024 is the cutoff date. Let's talk about this. This is coming out November 21st. The 4th U.S. Circuit Court has basically, in a 2-to-1 vote, stated that Maryland's licensing requirements are unconstitutional. And once again, they're coming back to Bruen. Let's jump in here. Maryland handgun licensure law is unconstitutional, U.S. court rules. A U.S. Appeals Court on Tuesday declared that Maryland's license requirements for people seeking to buy handguns were unconstitutional, citing a landmark U.S. Supreme Court decision last year that expanded gun rights, and they're talking about Bruen. A 3-panel judge of the Richmond, Virginia-based 4th U.S. Circuit Court of Appeals on a 2-to-1 vote blocked enforcement of a 2013 Maryland law that required people to undergo training and background checks before applying for licenses to buy handguns, saying it violated the right to keep and bear arms under the U.S. Constitution's Second Amendment. And that is true because the state is basically asking you to get permission from them to exercise a constitutional right. And that's huge because, and Connecticut people are just, yeah, I see you perk up a little bit. Yeah, that's going to be huge. The Supreme Court's 2022 ruling in a case, New York State Rifle and Pistol Association versus Bruen, required gun laws to be consistent with the nation's historical tradition of firearms regulation in order to survive a Second Amendment challenge. Quote, Maryland has not shown that this regime is consistent with our nation's historic tradition of firearm regulation, U.S. Circuit Court Judge Julius Richardson, an appointee of Republican former President Donald Trump, wrote in the ruling. Richardson called the Maryland law an additional preliminary step that subjected law-abiding people to a 30-day waiting period before they could begin the usual process to acquire a firearm through a separate background check system. Ronnie Kozak, the executive director of the National Rifle Association Institute for Legal Action, its lobbying arm, called it a significant ruling for the Second Amendment and every American who cherishes our constitutional freedom. That's kind of a, cookie cutter response, but I'm going to come down to a spokesperson for Maryland Attorney General Andrew Bruen, a Democrat who's defending the law, said his office is weighing options for next steps in this case. Now, at issue was a handgun qualification licensing requirement adopted as part of Maryland's Firearms Safety Act of 2013, a broader gun control measure. Prospective handgun buyers were required to submit fingerprints for a background investigation and take a 4-hour-long safety training course. They would then wait up to 30 days before undergoing the rest of the usual process to buy a gun. Now, that's just, once again, much like Connecticut, they're just making it harder for the average person to actually get a permit and go buy their gun. But a gun rights group called Maryland Shall Issue sued in 2016 along with 2 individuals and a gun store, arguing that the restrictions violated the Second Amendment, but a lower court judge twice rejected their claims, prompting the appeal. Richardson on Tuesday said Supreme Court in 2022 effected a sea change in Second Amendment law when it struck down New York State's limits on carrying concealed handguns outside the home. The test set out under that ruling has led to a series of court decisions striking down federal and state restrictions on firearms. Maryland has said its law mirrored historical limitations on dangerous people owning firearms, but Richardson said no historical laws worked by preemptively depriving all citizens of firearms to keep them out of dangerous hands. That's a great point. You know, some people may do something nefarious with a firearm, so we're going to make everybody liable for that person's actions. And here's the biggie. Connecticut people, pay attention. The dissenting judge, U.S. Circuit Judge Barbara Milano Keenan, an appointee of Democrat former President Barack Obama, dissented, saying the court's majority reasonings would render presumptively unconstitutional most non-discretionary laws in this country requiring a permit to purchase a handgun. Well, let's come out of that. And that's the biggie right there, especially because Connecticut does require a permit. This is going to have Tong and Lamont sweating. And I'm sure they're already looking at this and thinking, what's our next move to once again circumvent this ruling? Okay, this is huge. The court is saying you can't put onerous restrictions on people to exercise a constitutional right, which Connecticut does. This is huge for us too, because once again, this is going to open the door as it progresses to Connecticut residents filing suit against the state for their licensing procedures. Because one, it's long. Two, they just changed it to make it even harder and adding more, they want to add more training time, more class time. They just start throwing all these things in there. And on top of that, and here's the big one for us, they put this law into place with no guidelines. They say we want to expand the training in order for you to apply for your permit. But then they didn't tell us what those changes were going to be. They gave us no indication. They just basically said, well, submit your course to us and we'll let you know if it's good enough or not. That to me is just downright ridiculous and quite honestly unconstitutional. This is setting a great standard that is going to resonate throughout the country, especially those states like ours that have a licensing requirement. Huge news, huge news. This is, once again, we got another positive outcome going forward. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.